Hi, I'm Sean Bible, and I'd like to talk to you today about DUI. If you're visiting this website and viewing this video, you've probably been charged with a DUI. I'd like to give you some information about that and just pretend you're in the classroom, and excuse me if I'll look at my notes or if I pause. It's more important to me to give you this information and to look good on this video. First, what is a DUI? Well, there's basically two types of DUI. There's DUI less safe and DUI per se. People are more familiar with the DUI per se. Most people have heard of the DUI legal limit, which now is .08. It's at that number in every state as far as I know because it's tied to federal highway funds. The DUI less safe is something that people are less familiar with. That is what you can be charged with if you fail to take field sobriety test, or if the police don't have, or if the state doesn't have sufficient evidence or a blood sample or a breath sample, they can still prosecute you. So that's usually what people are charged with when they refuse to cooperate with a police officer and refuse tests. They can still be prosecuted. Also, which a lot of people don't know this, is you can be prosecuted in the state of Georgia even if your blood alcohol content is below that .08 number. You can still be prosecuted. It's not as easy for the state to prove their case, but you can still be prosecuted. The basic two DUIs that you see are DUI alcohol and DUI drugs. Most DUI cases can be divided in, between those two substances. DUI alcohol, again, you have the DUI per se, which is if your blood alcohol content's above .08, or you can have a DUI less safe, which is any case where the state wants to prosecute you for suspicion of being under the influence of alcohol and they don't have either a breath sample or a blood sample that shows a reading of over .08, or you refuse to take the test and yet they still suspect you were driving under the influence of alcohol. The DUI drugs is the same thing as DUI alcohol, except the suspicion is that you're driving under the influence of drugs. And I'd like to warn people who are watching this video, just because you're prescribed a medication doesn't mean you can legally drive. If you notice on your prescription drugs there may be a warning on operating heavy equipment, that includes cars. I have a lot of people that come in my office and they're surprised that they were charged with a DUI because they were taking their medication as prescribed. Under Georgia law, you can still be charged with a DUI even if you're taking medication as prescribed. Now, with that said, at the heart, what a DUI is the state is saying in a DUI prosecution that you are less safe to operate a motor vehicle because you're under the influence of drugs or alcohol. And that's what they have to prove. And it's the same reasonable doubt standard as you have in any criminal case. The state still has the same burden in a DUI as they do in any criminal case. Now, there is somewhat of an exception to that when you have a DUI per se and you show a blood alcohol content above .08. In those kind of cases, with some exceptions, what the state has to prove is basically they have to introduce that number in the evidence. If they can get that number in the evidence, they can more than likely convict you, although you still have to have a good stop. The police still had to have a reason to pull you over. And there are some very technical defenses to keep that number from getting into evidence. The police have to follow certain procedures, and there's some policies about how they conduct those tests and get that number, that blood alcohol content. And the same applies for tests for drugs in your system. And that's basically the overview of what kind of DUI prosecutions they are. Although there are a few additional things, that's the basic overview. Let's talk about how DUI arrest first occurs. The typical law enforcement encounter. Most people are pulled over. They violate some kind of traffic law. Perhaps they don't have a tag, the license plate is expired, they're speeding, they fail to maintain lane. For some reason, the police officer pulls you over for a traffic offense. Of course, there can also be arrest for DUI at roadblocks. Now, with roadblocks, certain procedures have to be followed. It's kind of complicated. You really need an attorney to look at those issues. Most roadblocks are perfectly legal, but there are some things that the state has to do to ensure that you can be prosecuted from an arrest made at a roadblock, and you need to talk to an attorney and make sure that your rights are protected as regards being stopped at a roadblock. Now, the more typical encounter, like I said, is a traffic stop. Pull over speeding, failure to maintain lane. A police officer can't just pull you over because you look like the kind of person that he thinks might be guilty of DUI. He has to have a reason. He also has to have a reason once he stopped you. Let's say you've been stopped for speeding. A police officer also has to have a reason to suspect that you're under the influence of alcohol or drugs. Most of the time that can be your demeanor, perhaps they smell alcohol. At that point, it's not enough that you're under the influence of something or that you've had some amount of alcohol. The state will have to prove that those substances have caused you to be a less safe driver than you otherwise would be. And the state proves that by field sobriety tests. The typical ones you'll see are one-leg stand, walk and turn, horizontal gaze nystagmus. Most people don't know what HGN or horizontal gaze nystagmus is, but that's the test where a police officer shines a flashlight in somebody's eyes, and police officers receive training on how to interpret clues from that HGN test, determine if somebody's under the influence of alcohol or drugs. Those are the three standard tests, although there may be, there are some other tests, ABCs, doing things backwards, saying things backwards, but HGN, walk and turn, one-leg stand, those are the common tests. And if a police officer determines after those tests or for whatever other reason that he suspects that you're under the influence of drugs or alcohol, he will ask you to submit to a blood, alcohol, or urine test to determine if you actually do have substances in your bloodstream that could cause you to be a less safe driver. A police officer has to give you an implied consent warning, and that's basically, it's usually on a little orange card. Most of the time, this is something that's been, required for a long time. For the most part, most officers, state troopers, county deputies will read from that little card or give the verbal warning. It's something they can memorize, so they may just give you that warning without the card, but they have to do that. Once they do that, they can lawfully ask you to submit to that test. You don't have to take that test. You don't have to give a blood sample. You don't have to give a urine sample. You don't have to give a breath sample. But if you don't, a police officer can do what's called an administrative license suspension or request that. That's a very important thing. If you don't take anything else away from this video, I want you to listen to this. If you refuse a blood test or a breath test after a lawful stop, a police officer can submit your case to the Department of Driver Services for an ALS or an implied consent suspension. And if you only have 10 days to respond to that ALS suspension. So you'll get a notice either at your arrest or on a later date, and that notice will be you have 10 days to respond to the police officer's request to suspend your driver's license because you failed to take a breath test or a blood test. And if you don't respond to that within 10 days, your license will be suspended before you ever get to court. The way, and this simplifies matters a little bit, the way I explain it to people is that imagine that the Department of Driver Services, the people that give you your driver's license, they have basically their own court, and they can suspend your driver's license, at least temporarily, before you ever get to the trial of your case. So it's very important because of that 10-day limitation. It's very important if you do get notice of that, you really do need to contact an attorney within 10 days or your license can be suspended before you ever get a chance to get to court. Past the ALS or the implied consent suspension in that court, which is administrative court, what happens when you go to court actually on your DUI case? What can you expect? Well, it varies quite a bit depending on what court you're in. A lot of times DUI cases will be in city courts, municipal courts, probate courts, state courts, and all those courts operate a little bit differently. Some people will have their DUI case heard in Superior Court, where the prosecutor is actually elected district attorney. So depending on what court you go to, your experience may be a little bit different. But regardless of which court you go to, there are a few things which you'll find consistently will be about the same. One is the punishment for DUI if you go in and plead guilty. And anybody can find what this punishment will be by going to the official code of Georgia and looking at the DUI statute. And if you walk in and plead guilty without an attorney on a DUI, the typical thing that will happen is that you may receive jail time. It can vary on which court and which judge you go in front of, and whether it's your first, second, or third DUI. You'll receive probation. You'll have to pay a fine. You'll have to do some amount of community service. You may have to take an alcohol and drug assessment. And you'll have your license suspended for some period of time, although you may be able to get a temporary permit or a work permit. All these things are very complicated and really do need to talk to an attorney. If not our office, I'd strongly advise you, if you're charged with a DUI, to talk to an attorney. The things which I've discussed with you today, it's just the very briefest overview. DUI law can be very complicated, and certainly it's not something that you want to go to court and represent definitely don't want to represent yourself on. And like I said, if you take nothing else away from this, remember, if you have been arrested, you need to contact an attorney immediately, if for nothing else because of that administrative license suspension, which most people aren't even aware of. So again, this is a very brief overview of DUI law. You'll find on my blog and in the frequently asked questions link, you'll find a little bit more information on license issues. Those can be very complicated. The law has changed recently quite a bit on second DUIs, for instance, and I outline those changes on my blog. So if you didn't get your question answered in this video, perhaps you need to go to my blog and read there. Or better yet, again, you need to contact an attorney, either our office or another attorney, about your DUI case. Thank you.